So the Albert Hirschman Centre has the pleasure to co-host this public panel discussion in the context of its ongoing consultation on informal and customary justice systems, asking the question of how to connect with the formal system and which pathways could we find to justice for all. So this is a collaborating endeavor that we have with IDLO since a few months, and actually since a couple of years. We are very happy to have this event today and to have the participation of Irene Khan, who will moderate the panel discussion and who will introduce the panelists. So we're very warm welcome on behalf of the Albert Hirschman Centre on Democracy, and I would leave Irene the floor.
Okay, thank you very much, Christine. First of all, thanks to the Institute for hosting us, and thank you all for turning up for this meeting. There's been a slight change in program. I don't quite look like Hina Jilani, so you will have guessed that unfortunately, she is not able to be here, but I think nevertheless we have an excellent panel and a good audience, and so we will have, I'm sure, a great discussion. Now, let me start by introducing the International Development Law Organization. I'm the Director General of the organization. We are an intergovernmental organization headquartered in Rome with an office here in Geneva and in about 17, 18 other locations around the world. We program on the ground. We also do policy advocacy. Our mission, our mandate is to empower people and to enable governments to reform laws and strengthen institutions to promote peace, justice, and sustainable development. So our starting point, of course, for us, for IDLO, is the rule of law. And while the definition of the rule of law varies depending on the political ideology, very often of the state, the rule of law is recognized as a principle of governance, and access to justice is also recognized by all governments around the world. Now, we will, of course, perhaps have debates about how universal principles of the rule of law are, but certainly what is increasingly, recognized as a reality is that there exists a plurality of legal systems. And underlying the rule of law are principles of human rights. If you take the definition of the rule of law as is understood by the United Nations, as is understood by IDLO, we would see rule of law as a system. IDLO certainly sees the rule of law as a system for operationalizing human rights, for operationalizing good governance, and underneath it all is the very important principle of access to justice. And modern development theory has also shifted from institutions to individuals, people's access to justice. And so it's rooted in the needs of justice seekers. And moving from that, of course, comes the question of the quality of justice that people receive. How does justice work on the ground? And that is where we see the modern discussion of customary and informal justice systems coming up, because when we look at the reality on the ground, then most people are not actually running to courts. Whether it's in Somalia or in Switzerland, we have informal means by which we resolve disputes. 80 or 90% of the world's disputes are resolved through informal means. And that, of course, then brings us to the subject that we are going to look at today. And a year ago, I was at a gathering of senior government officials from various countries, mainly from Africa, but there were a few from what we call donor countries, OECD countries. And it was very interesting. There was this senior Swiss diplomat who once he heard the foreign minister of Niger, the attorney general of Sierra Leone, and others talk about informal justice systems in their country. He started to talk about how the system of communes in Switzerland, decision-making is based on consensus, and that is also a form of mediation, negotiation, consensus building. And it was very hard after a while if we closed our eyes to figure out which was Niger and which was Switzerland. So you kind of see a common bond there of trying to figure out ways in which communities work and how they resolve their disputes. And on top of that comes the structure of the state and the formal legal system. So how do these things actually work? And for a long time, there was a theory that people would go to courts if they work, and if they don't have courts, then they go to the community to resolve, they go to customary law, but that's not quite the way it works. In fact, customary and informal systems is in fact the preferred choice for a number of reasons, because people are familiar with it, because it's accessible, affordable, flexible, speed, cultural relevance, for all sorts of reasons people are going there. And then you have, and it's not as though there's a pillar here of informal and customary system, and on the other side of formal systems. Actually, they merge. There are informal ways of resolving legal disputes, constitutional disputes, under the constitutional system, legal disputes. And then there are customary ways of resolving them. And there are places where the customary law is actually recognized by the formal legal system. So there is a range, a mixed mosaic that has developed now. And of course, each country, in fact, within a country, regions may have their own traditions, their own ways of organizing themselves, so that complicates the issue. Now, IDLO has historically had a history of research and programming that we have done on the ground, because we are an organization that works on the ground with people, and we have captured some of our experience over time. And recently, we published a policy brief as well as a practitioner's handbook. And we have launched, since the beginning of this year, what we're calling global consultations. We've had one in New York on the sideline of the Commission on the Status of Women. We had one in Rome in June. We had one in The Hague in the Netherlands last week. And we are having one here now and reaching out to various people, because we would like to test what we have found, what we believe, to see how others' experiences have been, and then try to build a constituency, a community of practice around this issue. Because this is the way in which 80 to 90% of the people in the world actually deal with what we call the rule of law. So this is the reality in people's lives. So what is the experience? What do we do? And there is increased interest also from the international community, from international organization, from the High Commissioner's Office, from development organization, from academia in this area. But like the formal system, the informal system is also a flawed system of justice. In the formal system, we encounter delays. We can encounter, in some cases, mismanagement, corruption, opaque systems. But in the informal as well, there are issues. And many of these issues, of course, relate to the understanding of human rights law, human rights standards. Human rights law recognizes legal pluralism. Human rights, customary or informal system of justice are not ruled out by the human rights system. But there are certain practices of informal systems that would appear to be inconsistent with international human rights standards. So how do we go in as an international community? How do we go in and work in those situations? How do we, I said earlier, the individual being the center of the justice system, how do we make the experience of justice better for them? And of course, what we see very often are discriminatory practices in procedure or in outcomes, unequal access to justice, for example, for women, for children, for certain ethnic groups, marginalized groups. We see some rights abrogating practices that are unacceptable because they are harmful to the rights, to the dignity of the human being, to the health of the human being. There may be inhumane, degrading punishments in some cases. So the modern state, the modern standards clash with many of these practices. On the other hand, we also see, and here when I say we, I say IDLO, with our work on the ground, we have seen that the informal customary systems tend to focus on the restoration of social peace, of harmony in the community. And therefore, as an organization that is working in many conflict-affected countries, like Somalia or Afghanistan or Mali, we find that restorative justice measures through the traditional systems can sometimes actually help the peace process better than the retributive systems that we would normally use. For example, in Somalia, we have had a project where we have helped using the customary system, the HERE system of healing ceremonies. We've been able to reintegrate low-level former combatants coming back into the communities. So that's been something positive. But on the other hand, we also see in our work that particularly when it comes to women's rights, when it comes to family disputes, when it comes to issues of domestic violence, there can be issues. It is very often the customary system is a patriarchal system of patriarchal values, and women, of course, is detrimental to women, women's right to land. In fact, yesterday, Reuters reported that in India, a march has started, a global march for a year from Delhi to Geneva. And this is a march to protest about women's access to land. And the Reuters report talked about the laws have been passed in India, the Hindu Succession Act, by which women would have equal access to inherit land as men, sons and daughters, the widow, and so on. But it's not actually happening. The law is there, but it's not happening in practice because the social custom still expects the sister to defer to the brother, the widow not to assert her rights. And so it's not making a difference actually to what's happening on the ground. The law is there, but custom is still prevailing. So it's and this is not India, I am using it only as an example. There are lots and lots of other examples of where you come in with a law and you think you've solved the problem, but actually it isn't solved. The old customs are there underneath and they continue. And then, of course, there are all sorts of more really horrific issues that we come across every day: honor killings, female genital mutilation. There are all kinds of cultural, customary issues that come there. And of course, our position of principle is very clear that human rights should not be subject to cultural practices, or rather cultural practices should not be used as an excuse not to respect and uphold human rights. Governments cannot abdicate their responsibility to uphold human rights. So governments cannot simply say, well, that's the customary system there, we cannot do anything about it and step out of it. The challenge, of course, is what do governments do? And that is where I hope the panel will focus on. How do we bring about change in these situations? What are the real challenges on the ground? There have been issues, there have been ways in which there are good practices about understanding what's happening through greater awareness, through engagement. We have examples in other countries where IDLO has worked. For example, in Afghanistan, we had a project on the Pakhtunwali practice of badal, where a woman is given in restitution for a crime or some harm that has been committed. And in this particular area, of course, the Afghans who practice that believe that this is part of Sharia law. And IDLO actually had to bring in Sharia experts to work with these village elders in this region and to explain to them that this was not Sharia law. This was part of their customary practice. And Sharia law recognizes women's rights and changed the habit there. The project was too short. The time was too short. It covered only a small part of Afghanistan. Whether it's been long-lasting, we don't know. So there are challenges even where changes come. And the change came through engagement with the elders, through education, through awareness. But very often we know, and this is both for the formal system as well as for the informal customary system, there are vested interests. So when we as a development organization come in, we have to be careful that we don't play into that system. There's going to be losers in any system, and what we want to do, when we want to do good, we may end up doing harm. So there is also issue of how do we manage that on the ground. This is quite different from the human rights world, where there are principles and there are standards, and you seek to reach them. In the development world, you're on the ground doing the work. So also bringing that development approach and the human rights approach is a challenging one. There are standards, there are principles, that's what we believe in, but on the ground, how do we make progress? I'm going to stop here now and ask the speakers. We have a very good panel here. Ask them, call on them one by one to talk about their experience, their knowledge, share with us. And then I would like this to be an interactive session. So as audience, I'm inviting all of you to interject with the speakers as much as possible. So I'm going to first call on Patricia Mbote. Professor Mbote is a member of IDLO's International Board of Advisors. She is a professor of law at the University of Nairobi and an advocate of the High Court of Kenya. Patricia, tell me from your experience as an academic, but you have also worked with a number of organizations. So in a sense, you're also a practitioner. So from that experience, of course, in Kenya, but in other countries, what are the challenges? What do we need to do to address the human rights issues within the customary and informal justice systems? How do we address this? And there's perhaps you might want to focus particularly on the situation of women, but on other situations as well. Are there lessons and approaches that we need to know as we engage as outsiders? And what are the insiders, the national authorities, the local communities? How are they reacting?
I think I'd like to start by saying that engaging customary justice systems is not a choice. It's because these are a way of life. For many people in the spaces we are working, customary justice systems are the go-to spaces because courts are not accessible. In Kenya, I think they say about 10% of the cases go to court. So if only 10% go to court and there are disputes happening, then there is actually other spaces that people are engaging. I think the other point I'd like to make at the outset is the fact that our constitutions allow for different kinds of laws. So we have formal law in constitutions and in statutes, but we also have religious law, we have customary law, and we have, I think, what anthropologist Sally Faulkner called the semi-autonomous social fields, which are norm generating and norm enforcing. And in all these spaces, disputes arise, and the resolution of these disputes requires anchorage in norms, in structures, institutions, and procedures. So with respect to the rights of women, for instance, customary justice systems come in where there is the question of inheritance of property. And the question is, if a woman is denied land, is she going to go to the court to vindicate her claim, or where will she go? And most times, people go to the local elders, the local authorities, and they trust that the local authorities will do the right thing. So I think one of the things is ensuring that these local authorities are equipped to ensure that whatever norms they put in place do not further marginalized groups. Of course, when a woman takes a matter to elders, the patriarchal system that Irene was talking about does play. Does the woman have a voice? Does she have standing? Does she have agency? I remember doing research among the Rendile in Kenya, and the women were saying that if you have an issue of domestic violence, you need to take that to the elders' court, but women can't go to that elders' court. And if women can't go to that elders' court, they must get a man to go and put the case. And right there is the double bind. Who is this man that you trust more than your husband to send to the elders? So in essence, ensuring that local systems are not, they are not just left out. We need to build the capacity of these systems, and especially to prevent the taking of property from women, whether it's also violence against women. Again, remember, this is not a traditional community. In one of the biggest informal settlements in Nairobi, Kibra, after the post-election violence in 2007, 2008, there were very many violations of women. And we were doing research and asking, did you take this matter forward? They didn't, that it was dealt with by the elders. Now you know that if there is rape, if there is defilement, those are crimes. But what the women were saying is the evidence requirements are so stringent that there is really no guarantee that you're going to get justice. So if you can deal with it at the community level, it is really best to deal with it at that point. And whilst the human rights aspects of that and the right or wrongness of that is questionable, one then knows that you need to invest in the communities so that as they resolve the disputes, you don't have further marginalization of people that are already marginalized. And I think I'm saying this to just show how ubiquitous customary justice systems are, that even when people know that there are formal laws, they will go to the customary justice system. I'll give another example from Machakos, where a member of a community murders another member of the community. And the question is, the sentence is either going to be imprisonment for life or the death penalty. And so the community comes together and asks, we've already lost one son. Should we lose the second one? And you know, we can talk about the fact that the person has done something wrong, there should be retribution, but the community thinks that it is more useful to restore this person to be a useful member of the community. And these are issues that have actually prompted the government to come up with ways of bringing in customary justice systems into formal law. We have a constitution that allows for the use of alternative dispute resolution, traditional dispute resolution, and this is not, it's actually pretty broad. In the access to justice provision, there is encouragement to use alternative dispute resolution. And actually in parts of the constitution, especially on land, this is specifically encouraged, and also in family law. So what has happened is that we now have the judiciary working on alternative justice systems to just see how you interface alternative justice systems with the formal justice system. And I think this is really not altruism, it is the realization that the formal justice system can be rendered redundant by these other systems. So the best way in thinking about access to justice is actually to interface the both of them. The other way in which this has happened is through court-annexed mediation. And IDLO has done quite a lot of work on court-annexed mediation. So whereas they are the informal at the local community levels, these days when you take a matter to court, a determination is made as to whether that's a matter that is amenable to mediation. And this has been done in commercial cases, and is happening a lot in the family division of the High Court. And I was told by the Chief Registrar of the High Court that the success rate for the resolution of family law disputes where they're taken to mediation is upwards of 80%. And many times because people want to talk about things, but probably haven't had a space to talk about these issues. So in essence, I'd say that engaging customary justice systems must happen, and it will actually promote the attainment of Sustainable Development Goal 16. Because when we talk about the rule of law, we are distinguishing it from the rule of men. And the way in which we need to assert the rule of men is by ensuring that the vulnerable are not further marginalized through the justice system. Thank you.
Thank you, Patricia, for situating it in the reality of Kenya and some of the other parts of Africa. You mentioned two points that I just want to highlight from what you talked about. One was the voice of women. Voices of women have to be heard. We had an interesting experience in Burundi where the government was introducing formal land titling. And when that formal land titling started, they started registering ownership of land. But of course, women in Burundi have customary rights to land. And the customary rights were not registered. The ownership was registered. And women, when the owners sold the land, the women discovered that they could no longer access that land. We came in, we assessed the project, we realized what was happening, and then started talking to groups of villagers, men and women, bringing them together to realize that if women did not have access to land, what did that actually mean? That meant less food insecurity. And so there was a community benefit in women's ownership of land. And these were joint groups of men and women talking and trying to figure it out. And then we saw, as they understood it, and women understood that the customary right to land was actually a right. They themselves also started speaking up in the land titling process. And in the end, we actually saw a marked increase of either co-ownership of land, men and women together, or women's customary rights being recognized. So getting the community to see the value as an incentive there actually brought about some change. So that was a very interesting point when you were talking about voices of women have to be heard. You bring them in, you sit down, and you do it. And that also showed the interface. You mentioned the interface between the formal and the customary or informal systems. If it isn't done well, then you can actually go back. And here in this case, land titling went in without recognizing the customary land rights system in Burundi. And so they were actually retrogressing. My next speaker is going to be Mona Rishmawi. She's chief of the Rule of Law, Equality, and Non-discrimination branch at the Office of the High Commissioner for Human Rights. Mona, of course, I would assume that with the mandate of the High Commissioner, human rights have to prevail. And would you say that we have to accept the incremental advancement of human rights because of customary systems of justice? How would you address the issues of flaw in procedural safeguards, flaw, accountability, discriminatory practices, and so on, to ensure fair, just outcomes for all men, women, children, all groups?
Well, thank you very much, Irene. Thank you very much, IDLO, for this kind invitation, and of course, the Graduate Institute. Always a pleasure to be here. Irene, you took the words out of my mouth. I was going to start by saying I am not a big fan of customary justice. I'm not a big fan of traditional justice. I grew up in a society where we fought customary justice. We did not accept it, particularly as women. So I'm not a huge fan of this system, but maybe we have to accept it as part of progressive realization of human rights. So I don't come to this from an admiration point of view. I come to it from a critical point of view. And I have to say, this is, of course, in my private capacity. Other people in the office might disagree. And actually, we have publications about customary justice systems and customary law. They are outside that you can check, you can look at them. But so, because I come from a critical point of view, I want to start by saying something positive about it, and then I'll come back and they actually rebut myself. So the first positive thing I want to say, we have to admit that these are indigenous systems, that they grow out of local customs and local traditions and so on. So as such, they are very powerful. They are really important, and many people really rely on them. So they are generally more accessible, culturally appropriate. They are, as we heard, often are the primary source of dispute resolution for people. In one country, in some countries, about 90% of disputes are really, they really go, as we heard, to the customary system. They are also, which is very important issue for many people, they are also less costly, and they are accessible in terms of fees and so on. And they use languages that are understood by the local population. So they are not foreign as such than many of than the foreign system. As such, because of these issues, there is often incentive, and we have to admit, there is a level of trust also in these systems. And they are much less intimidating than the court processes and the formality of the court processes that we know in many societies. So there are attractive things in this area. They also operate, and I think my colleague made this point very well, and also Irene, they also operate in areas where normally the state institutions are weak. Not necessarily in that the whole state is weak, but in these areas, the state institutions are weak, and the state institutions do not really reach out to the big population. So they serve a big purpose for, as you said, Irene, for peace and for social cohesion. And again, we shouldn't underestimate the importance of that. So the question for us as human rights people, okay, this is a system that exists, this is a system that is there, how can we work with it? The first thing that for us as the human rights, if you want, part of the UN system, is basically to really go back to the state and you say, okay, you as a state, you actually have committed to providing human rights to everyone. So the first entry point is actually what the state is doing with this system to ensure that human rights is actually implemented and given to everyone. So we would put the onus first on the state, and of course, working with us and other actors, of course, that becomes important. But there is a state responsibility to actually bring justice to all. I think the main problems, before I go to the main problems, I think there can be, and I don't see impossibility in having traditional systems operate in a way that is compatible with human rights. But there are three conditions that we have to take into account. One is that there has to be a legal framework in which they are operating. The role has to be clearly defined. We see them to deal with minor civil and criminal matter. We don't see them operating we don't see them able to deliver human rights in areas where we think there are very complicated due process and fair trial issues, but also where there are discriminatory practices, and when the issue of discrimination is really very important. We also think that, and I'll come to this towards the end of what I'm saying now, is we also think that there has to be a level of state supervision to what they actually do. Because without that level of the state supervision, the level of arbitrariness is really high. So the areas where we see a bit of incompatibility comes around equality and non-discrimination, particularly with regard to women, to reference to women, but also children, fair trial, double jeopardy, torture, right to life, freedom of religion, and some aspects of economic and social rights. I don't want to, because I don't have enough time, I just want to go through some, by way of examples, some of the areas that we actually see that perhaps can be remedied, but they need to be identified, because without them being identified, they cannot be remedied. So in many systems, they operate without any written comments, any written records, rulings or rulings. So the risk of arbitrary decisions is really high. The collective approach to justice, it's this tribe versus that tribe, really is very problematic and can really lead to a lot of problems with individual rights. And we see this a lot with the issue of honor, sexual violence, rape, and so on. So a woman is raped, the result is that the family gets 10 goats. Sorry. Woman's body is not to be measured with 10 goats. Or the woman is raped, and she has to marry him, the rapist, because otherwise it's the family honor. So this kind of stuff becomes extremely important. There are cases also, of course, in a lot of these cases, I think children are implicated as victims who basically their rights have to be. And we see that the idea of the best interest of the child is not really developed. So it's about the man and the woman, if you want, or the two quarreling parties, but where the child fits is not really very... So a lot of these customary justice systems are not familiar with things like best interest of the child. They use sanctions for wrongful conduct, like as I mentioned, which is really not compatible. It comes a lot in sorcery and witches and this kind of stuff. They are not compatible with human rights issues, and corporal punishments is one of them. I think the question of, you mentioned the case of murder, and really the issue of capital punishment is really a big problem. You know, we had it in my country that basically if two people, if somebody is killed, what do you do to avoid revenge, to avoid the other family taking revenge? So you get avoid revenge killing. So basically the traditional customary courts system kicks in, and then you find this situation in which basically I don't think in our system it will lead to the killing of someone, but it will lead to the banishment of the entire community. It would lead to a collective punishment. It will lead to the whole family of that person basically being banished from that location. The other quick issues I mentioned already about discrimination against women. We mentioned a lot about land rights, but there is also the issue of early marriage, the issue of divorce, settlements, inheritance, freedom of movement, and limitations on them. These are, I think, extremely important for women's rights. I think the issue of the voice of women is very important, and I think if we look at the structure of these courts, a lot of, and maybe in the second round I can make a comment on that, you'll find that a lot of these courts are male-dominated. Women find it very difficult not only to access the courts, but to be understood, because their experience, the experience of the judges and the experience of the people who are administering justice is extremely different. So there is a lot of reliance also with regard to women's rights. There is a lot of reliance of mediation and reconciliation, and that really favors often the male sectors of society. So I want to conclude this round, and I want to conclude this part of my intervention to say, I think there is a way to deal with customary justice, particular or traditional justice, particularly when fundamental human rights are not at stake. We are not talking about the right to life. We are not talking about torture. We are not talking about corporal punishment. We are not talking about serious discrimination in law and versus therefore practice. If the state creates a framework in which allows these systems to operate as systems of mediation and systems of reconciliation in much lesser offenses. So I can see a role there, but I don't see a big role. I don't see a role in the, let's say, where the fundamental human rights issues are at stake.
Thank you. I think you've given us a lot of food for thought there, Mona. You know, as you were talking, I looked at the panel. There are 4 women on the panel, and all 4 of us, in one way or the other, are subject to customary traditional systems of law in the countries from where we come. So it kind of, I think the personal experience here should also be something to think about. In my country, for example, my personal law, and this is true of all the former British colonies. I come from Bangladesh. All the former British colonies, the colonial power allowed the communities, the people, to retain their own system of law when it came to personal law. So family, divorce, property, or inheritance, all those issues were dealt with according to your own law. So whereas the public law, the criminal law and civil law, was then changed. So even to this day in Bangladesh, I am subject to Sharia law when it comes to my inheritance, to my family, to divorce, to child custody, and those kinds of issues. And that is true of many other countries too. So you actually have the 2 systems going side by side. And in fact, the personal law, the Sharia law becomes codified in the formal systems. So if I go to court on an inheritance issue or on a family law issue, divorce, I will be subject to Sharia law, which, although the Constitution guarantees equality of men and women in my country and in many other countries. So you have the constitutional guarantee of equality, and on the other hand, you have personal laws that still go down the track of customary traditional systems and then become codified. So it's a very complex picture there. And I'm talking here about educated, empowered women. And we are subject to the system, so you can imagine what it may be for others. Now, you mentioned a very interesting thing, Mona, and that is about clarifying, strengthening the relationship between the state and these informal systems, ensuring that the state does not walk away, and at the same time clarifying the responsibilities. I say it's interesting for us in IDLO because we actually have a program in Somalia where we are working with the HIR, what they call the HIR system, the traditional system, which is what Somalis have been using for decades now. Given the war and the insecurity, they have had no state system to turn to. But traditionally, of course, they have other reasons for remaining attached to the traditional system. Now, there is a state-building process going on in Somalia where the state feels threatened by this traditional system, but doesn't have the capacity to actually deliver justice for people, nor the ability to convince people that the state system will be any better than the traditional. So what our project is actually doing is trying to separate, delineate clearly what can the traditional system do well, how do we capacitate them, how do we get the local elders to do better at certain things that they ought to be doing, and how do we take away from them certain things that should really be the responsibility of the state. For example, serious crimes that you were mentioning. There are all sorts of issues there, of course, with counterterrorism and money laundering and all sorts of other issues that should not be dealt by the traditional system. So differentiating that, but strengthening the local system because they then have a vested interest in the reforms. So this vested interest part of it is actually a very important point to make. Of course, the other challenge with, particularly with those human rights sort of violations that take place is if you don't do a change strategy effectively, you drive them underground. There's a risk there. You talk about child marriage, for example. You get falsified birth certificates, or it happens anyway, and everyone keeps quiet about it. It happens with FGM, for example, has been a critical thing. So one of the issues there is all to see why these practices happen. Now, I would like to open it up a little bit to the audience now. If anyone would like to make a comment, raise a question, before I go to Shalini and Rochus. Yes? Is there a microphone? If not, you'll just have to stand up and speak loudly.
So thank you very much. Really rich and provocative topics. And as an anthropologist and a human rights practitioner, I feel like we're really in the space.
Do you mind introducing yourself?
Oh, sorry. I'm Meg Davis. I'm a fellow in the Anthropology and Sociology Department and also in the Global Health Center. And so I think we're in a place where anthropology and human rights really collide. And we really see this tension between culture and this sort of positivist international legal system, of which I'm very much a believer, but I think we really see here the tensions. And what's really struck me in this discussion just now is how certain kinds of law are being feminized, right? So the things that might come to a customary law setting would be sexual violence. We just talked about FGM. I think you mentioned family law, women's land rights. So those things could be dealt with potentially by a system that is or isn't capable of delivering justice for those marginalized groups, but its more masculinized domain is dealt with by the more formal legal structure. And so I just find that kind of tension really interesting, and I wondered if anyone wanted to
Yeah.
discuss it.
No, I think that's a very good point you've made. In fact, this is why I pointed out that all of us were subject to customary personal laws.
I think this is. I mean, we did a number of research on this, and basically we did 3 big rounds of consultation in Latin America, Africa, and in Asia, and of course in Europe there is also traditional customary practice. But what came out of this is that really women's rights and what people call the family space is really where this customary law operates. It's not the only one, because when the state is not there, of course they operate on a lot of levels. But in the majority of countries, that's the common denominator. It's really about the relationship between men and women and the relationship within the family. And in most of these situations, women are not represented as in the system itself. They are just users of the system if they can use it, if they are allowed to use it. So it is a real issue, at least from my side.
Any other comments? Yes.
I'm from the International Commission of Jurists. We're also a global organization working on rule of law, and so we also encounter these kinds of justice systems in many places where we're working traditionally since the 1950s, working to build up the formal justice systems. And if I had to say what our pre-existing policy was of ICJ towards these systems from the 1950s until more recently, it was basically ignore their existence or seek to destroy them and replace them with Western-style courts. And this was actually kind of articulated in some of our early documents. Since 2013, we've been trying to update that position. I think we've produced a compilation and some reports on consultations and really benefited also from the excellent work that IDLO is doing in producing on this. I think our starting point is very similar to what Mona Rishmawi articulated as her starting point, which comes maybe a bit from the fact we work with and are made up of formal justice system actors. But we kind of, in the course of engaging with this, I think faced quite a challenge from maybe the sharpest end of it from indigenous peoples. And within the framework of the UN Declaration on the Rights of Indigenous Peoples, saying some of the conditions, like Mona Rishmawi laid out, which is what the initial response of the UN human rights system was, you can deal with minor matters and we'll keep an eye on you. Basically saying this is a reproduction of colonialism. And why should we be restricted to minor matters? It's the most important family matters that we should be dealing with and not the only one. So this has been quite a challenge to us. And I wouldn't say that we know all of the answers to all the difficult questions it poses, and it raises further questions like, what if someone within that community asks for outside intervention to defend their rights right now? Should the response be, well, wait until your indigenous system things like gender discrimination, I think it can be a bit clearer. If women are not able to be decision makers, the goal is that women can be decision makers. On a question like how should judges be selected, again, some indigenous communities we work with say, we don't want a judge who's independent, we don't want a judge who doesn't know us, we want the opposite. We want a judge who's friends with both of the parties before them, because that's how our system works. So this is my second question, what should we be using as benchmarks? How do we, on the one hand, not abandon these standards that exist for a very good reason, but at the same time, not apply them in a way that destroys the essence of what makes these systems valuable? Thanks.
Thank you. I'll take one more question, and then I'm going to turn to the panelists again, and hope, if you can, the ones who are coming, if you can answer some of the questions, please do, but we will give an opportunity for others then to respond. I think you wanted the...
My name is Nasir Andish, and I come from Afghanistan, an example there. For us, IDLO is a very valuable partner working on the development of law. And as you mentioned that in one case, we are facing this, basically these challenges of not only this customary law, which is sort of a mix of traditional with a bit of Sharia and the others, but also a swift sort of justice law by Talib, and which, in some cases, the people in the villages, they go through simple issues because it's quick as judges, and normally they take the side of the court, just as a popular sort of Robin Hood kind of movement. But then, building in the state, it seems that sometimes not only not going into the areas where Mona was talking, of course, because I also believe that being in here, that implements the human rights development in a country like ours. But not even going there is the challenge that this kind of informal justice system, despite how important it is, it causes to state building, because it really challenges the authority of the state, and especially if a state is in the process of building itself up the way that we started in a couple of decades in Afghanistan. So I wanted to just to bring this to the attention of the panel, and given the experience, quite basic experience in the panel, they could tell us that how we can deal with this while understanding the importance of this at the village level, at the local level. This informal system works very well, and it's a way that it has to be done. But then when it becomes more, it goes to it empowers some sort of elders, which in one maybe at one level they will help you to deliver the justice, but then in some point of the time they can really stand against a state where they find out that their traditional powers challenged, and then it becomes a source of conflict, especially in the matters of human rights. So that's why when we go into back into the villages and try to explain to them the human rights, we have to be very careful not to this should look too polished. Basically, that it's coming from somewhere from Geneva. It's a standard which was made somewhere else in the Western world, and we are trying to implement it. So then the gap between these two will become a source of conflict, where when it goes to the parliament, and of course in the parliament, the parliamentarians will look into their constituency and they take their side. And we have CEDAW, where here as a bureaucrats we sign into it quickly, and it's a very good thing for us to do for our image as a state. But then when it goes to the parliament, every time we have problems into getting it passed. So I think this aspect is more governance aspect of how to deal with it and how to work with the locals. Do you have any experience? And on the panel, for me it was interesting because you're talking about Northern Afghanistan. I came from that part. It's not practiced in the northern. Which places?
This was not in the north. It was a project that we had a few years ago where the French peacekeepers were. And France started the program as a way of reaching out to the community. I think it was actually I will have to check it, but I think it was in the south. It wasn't in the north. It doesn't happen in the north, as you said. So it varies. In Afghanistan itself, you know better than me, it varies a lot. But
It's a
what?
code, basically.
Yes.
And that's, again, I
Yeah.
want to it's part of basically that
Yeah.
colonial time where we try to codify some of this, tribal customs, especially with the northwest frontier, which
Yeah.
is now kind of a question of
Yeah. That's right.
was,
And what it actually showed is that once you brought in, and we brought in actually Egyptian experts on Sharia, as you know, that's relevant, very relevant to Afghanistan, and that kind of a program on the ground, talking with the elders, made them realize that what they were doing was not quite what they thought they were doing, and that changed the mindset of the people. But I think the point that you're making, that when in states that are seeking to rebuild themselves, strengthen their institutions, at that point, we very often find, as you've rightly said, that this government, on the one hand, we say the government cannot abdicate its responsibility, but sometimes the government is struggling to establish its responsibility because of the various forces that are struggling. Now, our next speaker, I'm now turning to Rochus Pronk, who is the Counsellor of the Permanent Mission here of the Netherlands, and who was Deputy Ambassador of the Netherlands in Afghanistan, has had field experience on the ground in a number of countries. He was also head of the Afghanistan task force in The Hague, and he was posted in Bosnia-Herzegovina, in Ramallah, in many of these places where a lot of the challenges that you're mentioning has emerged. So, Rochus, and your government, of course, has taken great interest in the issue of customary and informal justice systems. The Minister for International Cooperation has been a very active champion of strengthening access to justice overall, formal as well as informal systems. How would, given your experience of peace building and the policies of your government, how would you respond to that question? What's been your experience? How does the Netherlands see this issue?
Well, thank you, Irene. First of all, thank you for inviting me to this discussion today in this distinguished panel. And when I was asked during the session of the Human Rights Council by your team if I could be on this panel, I hesitated a bit because I really do not consider myself an expert in this field. I'm a diplomat and call myself a human rights diplomat, but this is a field that I know a little bit, of course, from engaging in Afghanistan and other places, but I'm really not a renowned world expert on this. And also preparing for this debate here today, I realized that there is so much written already about this topic. So I just wanted to start with that. But I accepted the invitation because we are a big fan of IDLO. We believe that you do very important work in advancing the rule of law and development, and so I wanted to take up the challenge. So, first of all, just a couple of general remarks. I think the way we see this discussion, it's very much also from the SDG agenda. The question of access to justice is clearly a very important one when we look at the SDG agenda. Often when we talk about the SDG agenda, we talk about how we can end poverty, improve access to healthcare, education, and water. We forget that it's not always self-evident that access to justice is so key and a precondition for many of those other SDGs. So we believe that no society can prosper, let alone protect its rights, if there is no adequate access to justice. Lack of access to justice can also be a source of conflict. So the SDG agenda and SDC 16 is for us really fundamental because it recognizes that access to justice for all is key for the development of peaceful and inclusive societies. So that's a starting point. But we know that all too often there are many people who don't have access to justice in the world. And just a few numbers just to share for those who don't know, but there are around 253 million people live in extreme conditions of injustice. 1.5 million billion people cannot solve their justice problems. 4.5 billion people are excluded from the opportunities the law provides. And 1 billion people lack legal identity. And more than 2 billion people are employed in the informal sector, and the same number lack proof of housing and land tenure. 2.7 billion women live in countries that impose legal restrictions of women's employment. So often this absence, I wanted to also say that often the absence of justice is most visible, of course, in developing countries and hard to reach places, but it's not only limited to those places. I'm doing some research on this, I came across a study by the ICJ that in my own country, there was a study done a few years ago in the Netherlands that showed that in the Dutch legal system, victims of corporate human rights abuses who seek remedy through civil or criminal proceedings, and it showed that the potential for successful litigation in criminal justice systems, the formal criminal justice system, is also limited. So that access to justice also in developed countries is often an issue. So the way we look at it now, I think, is also evolved, is that we believe that if we're able to achieve SDG 16, we have to be willing to question our basic assumption of the justice system and how it is to function. In the past, we all talked about buildings and judiciary capacity buildings and workshops. And instead, I think we have come to the conclusion that we need to put people at the center. And we argue that it's not the availability of justice that makes a difference, but it's the accessibility of justice. So we need to open the justice sector, we feel. And it's not always necessary for the state to be the only provider of justice services. So formal legal proceedings aren't always the best and only answer in our view. And that means we have to look at the role of customary and informal justice systems. But often, these informal systems are their primary avenues. We've said it already, and they function in places where the formal system is weak. So to answer the question in front of us today, I think we believe it's very important to engage with these informal customary justice systems, and they can do a great deal to advance that goal of SDG 16, which is really a key goal for the whole SDG agenda. So we have to work together with both systems, and we also have to recognize that the formal system is also often flawed. It's not always so that the formal system is absolutely perfect. The formal system can also lead to human rights abuses and injustices. So we are very open. I think we've also evolved in that sense in our engagement in different countries, that we need to engage with the informal and customary systems. But then the question, of course, is what does that mean for human rights? Coming from a country that believes very, very strongly in human rights norms, I think, and I share what Mona said, there's a challenge. You've already mentioned here the challenges that customary and informal justice systems pose. There was just recently a report by the Special Rapporteur on Indigenous peoples that was presented to the Human Rights Council, and she also lays out very clearly in her report all those challenges, which I won't repeat here. But if you see that in many of the studies that there are major challenges with customary informal justice, and so the question is how do you strike that balance? And I don't really have the answer for that, Irene. But I think if we the fundamental question here is we have to protect the international legally binding norms, and especially today, I think when we see that human rights are under pressure around the world, I think it cannot be just about providing more access to justice and let's engage with customary informal in the interest of reaching more people. It has to be about applying fundamental human rights norms and that are binding in treaties. So I think we cannot sacrifice those norms just in the interest of access to justice. I think that is a really important point that we would advocate for. That means a strong human rights-based approach. It's non-negotiable. On procedural and on substantive sides, I think human rights norms have to be upheld. That is a challenge, of course. It's easy to say in Geneva, in the comfort of our chairs. The reality on the ground is often different. But if we strive for increasing that access to justice, and we have to engage and we have to be pragmatic, but the bottom line has to be consistently, and that means holding the states accountable, as we do hold states accountable also for their formal justice systems. We also expect that the formal justice systems abide by international norms and treaties. So I think we have to treat them at the same level, and I don't really have the answers, but I think it's important that the two systems complement each other, work together, and that if there are flaws in customary informal justice systems, that they can be addressed by the formal systems. At the end of the day, as Mona said, it's a state who's responsible for upholding those international binding legal norms. So, thank you.
Thank you, Rochus, also for bringing up the SDGs. And in a way, it kind of links up with what the ambassador was saying. The Sustainable Development Goals and the 2030 Agenda is a state agenda. Governments have come together and adopted that agenda. They are the ones who report every year voluntarily against what they are doing. It's part of their development agenda or international cooperation agenda or both. And the good thing about the SDGs is that they're applicable across the board to every country in the world. So everyone is being held accountable under that system. And justice is part of the SDGs. For the first time in the history of international development, justice has been seen as part of the development agenda. So justice has been seen as part of the state agenda, and particularly for countries that are struggling to establish the state, a coherent state system, strong institutions, there is a huge responsibility, I think, there for the international community as well as for the national government to establish the institutions. And it is within that institutional framework that informal systems have to work. I think that is what we are all saying, whether it's the Constitution, whether it is national laws, there has to be some kind of a framework within which, and each country, it will vary enormously from country to country, to what extent, what space there is between the formal and the informal system, because it's partly to do with the state of development, it's partly to do with the security issues that you have, it's partly to do with the development of democracy. And that brings me to another point. We haven't talked about much about it, but the justice seekers themselves, people, when we're talking about whether it's indigenous communities or other kinds of communities, you know, the voices of empowering people at the same time is actually probably the best way of ensuring what is it that people want. So in a way, we are at a very interesting point. Yes, human rights is under pressure, are under pressure and so on, but we are at a very interesting point where we see democracy, development, and human rights actually coming together. As we talk about peace building and sustaining peace, as we talk about sustainable development, we're actually looking at the thread of justice right throughout it. So justice, not in the sense of just going to court with a case, but justice as what it means to people. And I'll just tell you one thing. When I was Secretary General of Amnesty International, we did a survey on human rights, going out to people in the street and saying, what do human rights mean to you? And people actually stumbled, and not just in countries like Afghanistan, but actually in the streets of London, they couldn't give us a sensible answer as to what human rights mean. But everywhere we went, even in Darfur, I remember, we asked people, what does justice mean? And they understood the word. The answers didn't always match, but they had something to offer. And in that something, there was a common strain, you know, issues of equality, of fair treatment, you know, those, they call, in different languages, put it in different ways, but there was something there. And I think that is an interesting approach, and I say that to the human rights, being a human rights advocate myself, that we have to listen to different concepts and use different languages sometimes to be able to communicate across and discover what is beneath that. I think we get hung up very often with the framework and the norms, but beneath it, what are we really talking about? Shalini has been waiting very patiently for her turn, but I think we have provided you with some rich conversation and questions and comments. And I know that you have a lot of experience and expertise as the director of the Albert Hirschman Centre in Democracy here at the Graduate Institute, and through your own research as a professor of anthropology. I think there was an earlier comment about anthropology here and sociology. So I would like you to try to show us what does it really mean, these issues that we're talking about, in terms of integration of customary and informal systems into formal systems, from the justice seeker's point of view, but also from the point of view of citizen engagement. Because at the end of the day, how you can bring about change depends to an extent, if you're a government, on how much you can sell to your citizens. So what about citizen engagement, and what are citizens telling governments?
Well, these are large questions, and it depends on naturally what countries and contexts you're looking at these from. But just let me address the Afghanistan question with one very, very good study which we've seen recently of Taliban courts in Afghanistan by Adam Busko in Paris. And what this study shows is the need not to think about legal plurality as something which is a benign coexistence of systems of law, but a clash of antagonistic systems. And interestingly, I think what this study shows at least two things to get to your point. I think you're pointing to a really important paradox, which is on the one hand, there's a pressure on a country like Afghanistan to say, build state institutions. And on the other hand, there is a huge pressure to recognize non-state adjudication. And the two don't really go together. And I think states like Afghanistan, but Afghanistan is just a good example of this, they're caught in these totally contradictory pulls and pushes, and resources being committed to one, resources being committed to the other, without any coherent strategy of how this should go together. And we leave a weak state in civil war to really come to some kind of a solution to a problem which I think really needs to be addressed head on. So I think you're very, very right in pointing to a really paradoxical situation at the moment. What Adam Busko's study shows are two interesting things. One, that the Taliban is not using any local norms in the sense of the authenticity of some customary norms, but what the Taliban courts are using are Deobandi norms. So these are transnational Islamic, it's one school of Islamic thought, and so what you have is two transnational sets of norms, the Deobandi school versus human rights. So you have two transnational legal orders which are actually at conflict with one another. And what it shows is that the Taliban courts are extremely conservative. They are not Robin Hoods. They are not for the poor, and they are not redistributing property. That they are actually both extremely good at upholding patriarchal gender norms and upholding private property relations. This came as a great surprise to me. I was one of the examiners of these theses, so I've read it very carefully. It's an interesting one. I will pass this on to you. So there is a difference here between somebody, a group like the Taliban, and, for example, Maoists in Nepal, who have much more progressive ideas of redistribution, or the FARC guerrillas in Colombia. So it's not as if all insurgent and rebel groups are conservative. They can be progressive on certain matters of redistribution. They can be conservative on others. I think we need to really look very carefully case by case. And what he also shows is that the reason people are, and even people not supportive of the Taliban, are using Taliban courts is partly because the Taliban judges are seen as impartial. And he has a very interesting understanding. He shows what people's understanding of impartiality is. The Taliban is systematically training their judges, not allowing them to take money from the people whom they litigate for, and they are rotating their judges every couple of years. So no judge is allowed to get enmeshed in the local politics of the area. And that is what people see as neutrality and a guarantee of impartiality. So I'll stop with the Afghan case on that.
There's something to learn.
Yes, no, it's a very interesting way of running a parallel court system. And this is why I think it's a misnomer, as I was saying this afternoon, to call this an informal system. It's a formal system. They are training, they are rotating, they are bringing a lot of literature on these Deobandi systems into the villages where they're working with the people. So I think in the end, it will be a question of asymmetries of power and asymmetries of resources as to which of the system is going to get the upper hand when this situation
also,
concludes.
the other point from what you're saying comes out is people's value of justice. So how
Absolutely.
they are seeing a court independence of that system. Those values that they hold are not so different from values that we would have about what is independence. So
this is the interesting thing.
That's
Yeah.
also very
However, we should also not forget that legal pluralism is just not an analytical category, it's a normative category. And the normative category is that it reflects the diversity not only of people's legal understandings, but of people's moral norms as well. So there are competing moral universes, and I don't think we're going to get a universalism there. I think people have different understandings of what women's roles should be, what a just distribution in inheritance terms is, whether we should be upholding individual rights to property, or should we uphold communal rights, should property be treated as commons, or should it be treated as individual rights, etc. So I think we have differences, and so there is a normative pluralism in that legal pluralism, and I think we need to address that question. We can't skirt the question of saying that there is a universal normative framework and only different legal institutions. So I think there is a problem there to be addressed. But that's one thing. Let me come to your question on indigenous groups, because I'll take up Irene's point that all of us come from countries in which there is a de facto legal pluralism. And India is a very good example where I come from. The Indian Constitution recognizes only the rights of indigenous communities. It doesn't call them indigenous. These are the Adivasis, the communities. And it says these are the only communities who are allowed to have legal autonomy. Yeah, so it recognizes the legal autonomy of the rights of those communities. But it recognizes them in a limited fashion. So it doesn't recognize necessarily fully their rights to autonomy over their resources or their land. And this is where the clash with the mining companies comes in, which is one of the things I'm investigating, but it's a different story. But it recognizes over family law, it recognizes their legal autonomy. Then there is a whole set of new laws, new legislation in India, which gives forest rights to these indigenous communities, etc. So those rights, the collective rights or also individual rights, are coming from other sets of laws. So there is a complicated legal framework there. Then there is what Irene mentioned, which is another kind of legal pluralism, which you would be familiar from, for example, from Lebanon. You have different personal laws similar to Bangladesh. This is the British colonial legacy to all of our countries. You have different sets of parallel legal systems depending on whether you're a Hindu or a Muslim or a Christian, etc. But in India, you have the possibility to say, as a Hindu woman, to say, either I go by the codified Hindu law or I can go by civil law. So you can have a marriage which is registered according to civil law, or you can have a marriage according to the Hindu law. So there are different sets of possibilities. But in addition to that, something which is de facto recognized but not de jure recognized is the plurality of caste customs within Hinduism. So there is, this is a plurality at a very different level, and I want to just say very quickly something on that, because that ties into a little bit of the kinds of arguments Patricia was making. So this is about the plurality of caste customs at the level of inheritance, marriage, divorce especially, child custody, etc. And this is lived plurality at the level of everyday life. And this is a self-organization of castes, but entirely caste councils which are composed entirely of men. So women are represented in all of these caste councils by their fathers, their brothers, or their uncles, etc. Now, the question is, by what criteria of gender justice are we going to measure these? So I've done a lot of field work on these caste councils, and I just want to make 2 or 3 points here which may be interesting. My first idea was to say women are being actually disadvantaged because they cannot represent themselves. And women said to me, isn't it better that your father or your brother represents you than a lawyer who's never seen you in your life? So this was my first lesson to be learned about who should speak for me. And it has disadvantages, of course. Yeah, if you're on bad terms with your brother, you really had it. But the question is, do you want to go to a complete stranger whom you have to pay to represent you in a court in a language you don't understand, in a setting it is not your own? Or do you want to be represented by male members of your family? So this was one question. The other one which I found very interesting was I said courts are expensive, so you're using caste councils because they are cheap. And they said, no, we need to bribe the judges in the lower courts as well, and we need to give lots of money to the elders in the caste councils who are deciding on the decision. So money gets spent in all cases. But it's much better to invest the money in the caste council because you're never going to see the lawyer and the judge again. You're investing in strangers. We pay money to the caste council. We are investing in our relatives. We are investing in social relationships which will stand the test of time. So you are investing in another set of relationships, which are, so the legal is enmeshed in your social relationships. So this is just to give you a flavor of some of the conversations I've had with the women. On formality, informality, and coloniality, which we just discussed, it was very interesting. Every time I went to a caste council meeting, I said, what are the rules you adjudicate by? They pulled out a little printed booklet and said, this is our constitution. And I wondered where these printed caste constitutions were coming from. None of them could tell me. So first of all, it's quite formalized. The structure of the discussion, the way in which the dispute must be carried out, the rules are all printed, etc., etc. And then I discovered that the rules come from British colonial codification. There was a British commissioner called Mr. Borrowdale, who in 1826, he was the commissioner in Bombay Presidency, he wrote a questionnaire for caste council leaders to give him the customary law so that the British could adjudicate by the customary law. Every caste constitution which I got follows exactly Mr. Borrowdale's questionnaire without knowing what they are doing. And every few years, the caste gets together and it amends its law. So you have a reform of the constitution by the caste itself. So you have enormous degree of self-organization, you have a formalization, you have a codification, and the interesting thing for me was, if you're thinking now in terms of hierarchies, you would think state law trumps caste law, but it's exactly the other way around. And let me just give you a story and stop. So why does state law not have the authority it should have over caste law? Every time you go with a dispute, and these are all lower castes which are still using these, because if your caste is extremely mobile and people are spread all over the country, then you can't hold your caste together. So the upper castes and the middle castes are not involved in this anymore. But the lower castes, and that's like 60-70% of the rural population and also urban population, have caste, functioning caste councils in Western India. You go to the lower courts and the judge will ask, what caste do you belong to? In a country in which caste is officially, of course, abolished by the constitution. And then you say caste so-and-so. So what would be the rules of your caste for divorce? And the official courts will go by what the caste custom is, because the judge knows he can give you whatever decree, but if your caste doesn't accept it, this decree just doesn't work at home. And so I asked the people, I said, why do you go to state courts if you have a caste council? They said the whole purpose of going to court is to harass our opponents. It's not in order to get a valid decree. Nobody goes to court to get a binding agreement of any kind, but it makes the life of the other guy completely miserable. So you change the politics of the case on the ground at home, and you use the court as a leverage to change the entire situation. And this was very interesting to observe, because I did 2.5 years of fieldwork among the Dalits, the so-called untouchable castes, looking at the workings of caste councils. And it was very interesting to see how the one feeds into the other. And my last story on this, so I said, why do you then prefer to only use the caste council rather than use the courts? And they said, because you can get a divorce in a court of law. Who is going to marry a girl or a man divorced in a court of law? He has to get a wife from his caste. The judge is not going to give his daughter in marriage. So unless you have a divorce decree from your caste, it makes no difference what the state court has done with regard to your divorce. So you have a very different hierarchy than you would have expected. You have a very different relationship between caste councils and state courts than you would have expected. And you have people maneuvering both systems, dovetailing them in very different ways from one another. So I think the empirical question, and that I come back to the question of what does an anthropologist do, I think an anthropologist doesn't start anymore from institutions or from actors, but from relationships. And what an anthropologist does is to ask herself the question, what legal forms emerge from everyday practices, and look at the question of how does legality unfold in a particular context.
Thank you. Thank you very much, Shalini. I'm sure that's given a lot of food for thought for people, particularly the reality on the ground that you're talking about. Because in a way, if we're going to bring about change, we have to understand the context, we have to understand the stakeholders, we have to understand the relationship of the stakeholders, and start with the principle of do no harm, first of all, because coming in as outsiders, I think that's the huge risk, and then try through the actors. There's an empowerment agenda there of whose voices are being heard and who's not, and what happens when people are educated, when they get the information, when they are aware.
So maybe just one, because we have Mr. Pronk from the Dutch Ministry. So what the part of the Dutch development aid in the 90s was to set up a women's empowerment program in India, Mahila Samakhya, and as part of that program, they set up women's courts. Mm-hmm. And these were, the Nari Adalats as they are called, and these were very interesting experiments in state law, but carried out through women's NGOs. And one of the experiments which I looked at, which was not part of the Dutch financed program, but the program was very interesting, is in Rajasthan, where the women argued, look, there's no point in wanting to get away from the men's caste councils, but we need women's councils. Mm-hmm. And so they set up, analogous to the men's caste councils, women's councils, which were not restricted to the caste, but they were women's councils modeled on exactly the same way that caste councils functioned, because they said it would be wonderful to get the husbands to come into this arena only where the women are sitting, and the husbands have to now answer questions. And then they got the women and the women police officers to come and help them enforce these decrees. And so you had parallel women's councils, which were formed pretty much like male councils, and the question of enforcement then was dovetailed with women police officers from the state. So we've had actually in the last years very many interesting experiments. And we had, for example, Muslim women's groups who said, look, there is no way to convince Muslim women to not have a Muslim marriage and to go for a civil wedding. So let's have a women's nikah nama. And why can there not be feminist nikah namas? And so in Lucknow, you have 6 different groups which have produced nikah namas of their own. Some are more feminist and progressive than others, and they are competing as for citizens and users to say, I would rather use this rather than that. Yeah. And I think that's where it becomes really interesting.
And India is not the only place where that's happening. It's happening in a lot of places. You take Bangladesh, my own country, and very often this empowerment of women, in Bangladesh we have what at the village level what they call shalish, which is basically a mediation system, which is increasingly being sort of taken, I wouldn't say taken over by women, but certainly an integration of women, and reforms are taking place, very often driven from the bottom up. And there is investment, good investment being made in those kinds of things. So this one element that has come up a number of times from what you've been saying, and others, panelists as well, and from the audience, is the empowerment of the people. You know, things change. Culture is not static. And very often, what we haven't talked about at all, we've talked about society, we haven't talked about the economy. And economic power, changing economic power of women, is also having an impact. In Bangladesh, it has been driven by the microfinance movement, which has very much empowered women and the garments industry, for example. And women are therefore becoming louder. And the government, similar to Afghanistan, where you mentioned, Ambassador, that parliament is not always the most progressive part of state institutions. And the president, Afghan president, has actually issued an edict, a decree, on elimination of violence against women, because he knows that if he goes to parliament, there'll probably be a backlash. Similarly, in Bangladesh, which is also a majority Muslim country, and therefore Sharia on women's inheritance, the policy, the government has issued a policy calling on more equal treatment of women in the context of property. For example, what they earn, they keep. They may not inherit equally, but at least their own property is there. So that's a first step, and now they're trying to push on inheritance. So changes are taking place in ways which are quite interesting. Now, I'll open it up for a few questions, but let me just pull out a few things that might want you to think. One is we talked about peace building, but in the peace building situation where countries like Afghanistan or Somalia or Mali are struggling to, between their institutions and their informal systems to gain legitimacy, there the investment is usually very low in justice, very high on security, very low on justice. And that kind of creates an imbalance where the state then struggles to establish itself when it is challenged by forces like the Taliban. The other question I talked about the economic issue. Now, the economic issue we know can change. A lot of the practices underlie at the end of the day, whichever way you follow, it's about money, it's about land, it's about power through economic power. So one needs to bring the economy and society together, perhaps. We talked also about competing moral norms. Normative pluralism as well as institutional pluralism. I think that would be a very interesting discussion, but we probably would need another day for it. It would be possibly challenged to some degree, because I think, yes, there is normative pluralism, but there is also normative convergence taking place. The world is becoming a much more global place than it was ever before. But I'm going to open all this to you, and you, the audience, tell us whether we are getting it right, what are the gaps, where have we missed out. Let's hear a little bit from people who've been listening to us. The lady at the back, and then the gentleman in front. Yeah.
My name is Anjali Lebra, and I'm a researcher currently looking at mobility with Ecuador. And so this is a place with many indigenous places. And the question I have, I would love to have your views on what is the scope of customary law, or in my case, what I'm looking at is more indigenous law. Who does it apply to? Is it only to people who belong to the group, or does it go in a broader perspective? Because recently there was a political crisis in Ecuador, and so the indigenous movement was very strong. And at some point they arrested policemen from the Ecuadorian police force, and there was a statement that they would apply indigenous justice.
Okay.
And that did not
Good.
come out, but then,
Yeah. So let me move on to the next. I'm sorry, I'm rushing a little bit to give people an opportunity.
Sure.
Yeah.
My name is Nick Mansfield. I work with an NGO called the East-West Management Institute, and we do rule of law development programs in a number of countries. Looking at this issue from a development perspective, I guess the question in my mind is whether engaging with customary justice systems is worth the effort. Does it produce the result that we want? And so I guess with that thought in mind, my question is, are there examples we can point to, good examples of patriarchal systems, customary systems like the ones you described? Are there examples where such systems have been reformed, have been made less patriarchal, less sexist in a really comprehensive and sustainable way as a result of the intervention of outsiders?
Okay.
Outsiders,
That could also apply to the formal system, of course.
well, yeah.
Yes, sir.
Yes, my name is Pierre Horner. I work here in the United Nations Secretariat, the legal office, on trade and development. You mentioned economic issues. I just wanted to make a small comment of what Professor Randeria said on the issue of the social fact. And actually it strikes me this idea of this a very old version of what is the meaning of law, which is a three-dimensional theory of law that was established years ago, when you have the social fact, the value, and the legal norm. It's triggered by the social fact being the sociological aspect, is valued by the axiological aspect, and then due to this, it produces a legal norm, not the other way around. So this three-dimensional theory of law has been triggered in many countries around the world because it's based on the social factors, what you said earlier about the interdimensions and relationship between the societies, what you were mentioning about the caste system in your country. And then it goes to the axiological value, which is the values, and then of course it produces the legal norm. And of course, in many societies, as I see in the work I do in the United Nations, many legal systems tend to obviate that part, and they just go into the norm, and they associate law with the act itself. So that is the problem in many societies, and therefore I would like to ask whether you have thought about this three-dimensional theory of law in your research.
Okay, yes, at the back. Yes.
My name is Patricia. I worked for many years in East Timor in the justice system. My question is regarding the linking or the need to link these two systems.
Sorry.
To complement the two systems, can we see or look into the legal involvement of people as an entry point to better connect the formal and customary work?
Okay. Okay. So let me now turn to the panelists who would like to go first. You don't have to answer all the questions. You pick and choose which one you think is most relevant for you.
I'll pick up one.
Okay.
You want me to go first?
Yes, go first. But we need to limit the
Very
answers.
quick. I'll pick up your question and yours together. And I think, so I'll give you one concrete example, but we can think of others as well. And I'll pick up yours, which is a more theoretical question, but I can't give you a large theoretical answer. So I think the more important thing for me, rather than the three-dimensional theory of law, is to think about how normative, that both state and non-state institutions, legal and otherwise, are embedded in normative orders. And I think that's the relationship that one needs to think about. And here I think the work of someone like Rainer Forst in the last years is very interesting for me, because what he shows is that you need to legitimize legal authority, and this embedding is a question of what he calls narratives of justification. So Islamic law is a narrative of justification, so is the narrative of communal harmony, so is the narrative of liberalism. These are all narratives which justify, produce justifications, public justifications for the use of one set of norms as against the other. So this would be one way of thinking of the relationships that you are postulating. And this brings me to the question that you were asking. So it's a very interesting book by Tobias Berger, which you may want to look at, on Bangladesh, actually. It's on the relationship between the Shalish, which Irene just mentioned, and what are called village courts. And these village courts are established or have been strengthened, not established anew, but strengthened, so these were colonial institutions, but strengthened through EU and UNDP grants. And what Tobias Berger shows is that paradoxically, the local, so he's looking at translations, he's looking at processes of translations, how rule of law norms and human rights norms get translated on the ground through Salish and through village courts. And what he shows is that paradoxically, rule of law succeeds exactly there where it loses its Western appearance. So if it needs a translation, and it needs to be translated out of the liberal language of individual rights into the language of community harmony. But that can be a successful translation when it's mediated by the use of Islamic law, which also has ideas of gender justice. So the question is, can you marry some of these ideas which you are bringing from outside and translate them into a local idiom, and who those translators could be? And he looks at certain local NGOs as successful translators. And then he has very good examples of non-successful translation, where one tries to have a one-to-one kind of language of human rights, and it doesn't pick up, has no local traction. And then he shows what has local traction and what doesn't. And one very interesting argument which he makes in his book is that the Weberian idea is that documents, because all courts need documentation, right? So our idea, or our modern Western Weberian idea of documents, is that they are neutral vehicles in which some information is carried or the other. And he says that's exactly how documents don't function. And he shows how documents function in such a system, and he shows how systems are able to use documents as part of the generation of symbolic capital around certain documents, and that is what makes them valuable. And if you can posit yourself as an actor who is able to give value to my electricity bill or my land title or whatever identity documents, which if you are living in an informal housing community, which you have to provide, those are the kinds of translations which then embedded all of these Western legal artifacts, norms, institutions into, are able to translate them into a local idiom, and then these are successful. But they are successful in their departure from Western ideals, which is a really paradoxical thing, but only if they use local idioms, for example. But it's a very, very interesting study because you can see foreign actors, foreign resources, and which NGOs are able to translate what and channel it into which kinds of successful local solution generating
Patricia.
Very quickly, I think when you're looking at customary norms and customary justice systems, they haven't really gotten much light of day, because for many post-colonial societies, many of these norms were actually subjected to the rule of whether they were repugnant to justice and morality. And right there, one asks whose notions of justice, whose notions of morality. And there have been examples where just going on this and looking at how do you secure the rights of women in communities that don't allow women, for instance, to have rights to land. And in Kenya, there are non-state actors, the Federation of Women Lawyers and others, who have worked with local communities, you know, with the elders, like almost calling them out and saying, you go back to the root of certain norms within communities. No community allowed people to be thrown out. So they'd ask, on what basis do you tell a woman whose husband has died that she has to leave the land? So in essence, you go to the principle of humanness, the community's care for its weak and vulnerable. So in essence, it's challenging the norms that have come in of individualism, capitalism, and looking at where did we come from, and how can we go back there to ensure that everybody's rights are respected. And you engage the powerful, who are the elders. And the elders then become the change agents within the societies for the rights of women.
Okay. Rochus, would you like to respond to any of the points?
I don't really have a response to all the questions, but maybe just a closing remark, if you allow me,
Sure.
Irene. I think it's very interesting and informative discussion also for me. But just wanted to maybe draw the audience attention to an initiative that my government is part of. I think it might interest people who don't know yet about it. This task force on justice that we are part of. This is an initiative led by what we call sort of a multi-stakeholder partnership of 30 member states, international organizations, civil society, private sector, and aimed at to accelerate the delivery of SDG targets for peace, justice, and inclusion. So we held a big conference earlier this year. The task force is led by Argentina, Netherlands, Sierra Leone, and the elders, and there was a big conference this year in The Hague. and that, if you Google it, you'll find the reports and all the documents, and it's really, I think, very informative. But one thing I noticed there is that what that effort also did was the costing of justice for all. What does it cost for societies? And just a few figures that I thought I'd share with you. It was estimated it would cost $20 to provide each person with access to basic justice service in low-income countries. In middle-income countries, it would cost $64 per person, and a high-income country, $190. Now, it would cost $141 to provide universal primary and secondary education in low-income countries per year, and universal healthcare costs in low-income countries $76. So it's also prioritization, and the conclusion is that for many middle and low-income countries, it will be difficult to invest in access to justice for all. That means that you have to look at alternatives and work with customary and informal justices. So that's a fact of life there. There we have to engage with them. But the challenge is, and that's something I consistently, personally also struggle with when I hear this discussion, is where do human rights fit in customary informal justice? And I think really that's when I also look at the debates in Human Rights Council and the narrative from many countries, that when we talk about SDGs and human rights, the narrative is, well, we develop first and then come human rights. And I think that is something that is just not negotiable. And so when we work with customary informal justice systems, we have to, as we do with formal systems, continue to insist on the application of legally binding international human rights norms, procedural and substantive norms. So I think that is the major challenge. The question is, was there ever a successful engagement with that led to a transformation of informal customary justice systems that improved? I don't know. I asked also my own colleagues in the Netherlands from development side of our ministry, what are we doing at the moment in engaging with informal customary justice systems, and have we success stories? I don't have them. I worked in Afghanistan a bit myself in the past, and we focused very much on capacity building of the formal justice systems in Afghanistan. We also worked with tribal engagement and dialogue, but the main effort was building a state, building capacity of the formal justice, and holding the state accountable in the end for all these human rights norms. So some general remarks. Thanks, Irene.
Good, thank you. Mona.
Just a few remarks just to conclude, and also answer some of the questions. I think the issue of indigenous is very specific, and particularly the discussion about indigenous people, and it's very related to the autonomy, it's related to self-determination. I don't think we can take it to apply to every situation everywhere. So I think we have to be extremely careful. I'm sensitive to the issues, but also hearing indigenous women speak on these forums, I'm also sensitive to their concern, and their concerns are not to be underestimated. The other thing that I want to, we engage, everyone engages, I think, to a certain extent, to different extent, with the informal system. And I would want to make a distinction between why we engage, the methods of persuasion, how do we engage, and what's actually the parameters of these engagements. Why do we engage? Most of the time is because they are part of of a way in society to establish law and order. Let's be honest. That's why most people engage with them, because they are there and they can establish a certain parameters. How do we engage? I think we have to apply whatever system of persuasion, whatever methods of persuasion that we have. But the most important thing is the ultimate goal. And to me, the ultimate goal is that these systems protect the individuals that they are adjudicating in the same way that we expect any other system to protect the individuals that they are adjudicating and to protect their rights. If we let go of that objective, we are letting go of a big thing. And I think we should be very aware of it. We can theorize it. We can conceptualize it. But at the end of the day, there is a woman who has to go home and she has to feed her children, and she has, or he, because sometimes it's the man, he has to also feel that he has the dignity and respect within their society. And if the system cannot grant that, there is something wrong. So we can develop this in any way we want. So to me, I go back, I recognize 100%, and I'm very grateful to the question on East Timor. I actually had it in I had a big thing about what happened in East Timor. So I'm very grateful that, you know, in certain situations, and also our colleague, the ambassador of Afghanistan is not here, that actually what he mentions is also very important. State building is not a small endeavor, and we are very aware of that. And of course, state building and state institutions, one has to be patient and often you have to find a way, again, a workable solution. But to me, the objective will not be different. The objective will always be, how do I retain the dignity and respect for the person in front of me, in front of these systems? So to me, I would bring it back to, you need formal structures, and without the formality of these structures, integration in the national system, procedural safeguard, training, whatever you call them, paralegals, whether it's the father or it's someone else, but you need a system that makes people feel that you can, accessing this justice area, again, and the last word, preserve their dignity. And that's not what we are seeing in a lot of these systems.
Okay, thank you very much to the panelists. It will be hard to try to summarize what each of you have said and what we've heard from others in the room. It's obviously an area where there's change taking place, lots of things happening. But the important thing is that there is a light being shone on this neglected area of justice and development. And I do add justice and development because they both go hand in hand. Of course, context is important, local ownership is important, the relationships, the power dynamics are important, and they're usually very complicated because they're contested. They're contested in countries like Afghanistan, but they're also contested in countries like India or Bangladesh, where there is, growing economies, changing politics. So these are all sort of, if I can put it this way, the realities of life. But at the same time, I would actually say that there is change happening. Not in the way in which the international community thought about it, not in the way that perhaps donors have invested, but always you get this sort of unexpected consequences. And there is a lot of that unexpected consequences happening, both good and bad. And that is what, your academic research, for example, is showing from the ground. And that is what we, as a practicing organization, also find happening. And what we actually need, if I was to get very practical as a development practitioner, I would say what we need is much more flexibility in the way we are allowed to design and deliver programs. Not to start in the beginning thinking this is what is going to happen. You go in, you work with people, you listen to them, you start understanding them, they start reacting, and then you see where there are opportunities for change. And empowerment agenda, we haven't talked about it. The empowerment strategy is a very important strategy. It's not just empowering individuals, it's actually empowering communities. Sometimes we've had interesting projects, for example, in East Africa, where we have empowered women and young girls at risk of HIV to be able to hold accountable the health providers, the legal service providers. So even there, they're all NGOs, but even between the NGOs and who the NGOs work for, there are issues there. So I actually feel quite energized when I look at that level of people. Lots of things happening. But when I look at the bigger picture, then I get worried. Because the bigger picture is where we see the risks, where we see the cracks, the attacks on that larger framework. And somehow we need to, of course, we always need to change the language. I remember when I was in Amnesty International, we were beginning our work on economic and social rights. The campaign we launched on the relationship between human rights and poverty, we called it human dignity, because that resonated much more with people than talking about human rights. So language changes to make it more understandable to various people there. Sometimes even translation, literal translation, can be dangerous. So of course concepts change, but the fundamental aspiration of a human being, what is that? That is not so different. And that, of course, is affected by their state of development. So I think as we get more information, as we share more. I think there is, I would say that you will also find that, yes, there may be some normative differences, but there are some commonalities also that are coming up. And we need to try to understand the trends that are happening across regions, across countries. There is probably more in common between South Africa and Mexico than South Africa and Mozambique. Sometimes it's the level of development, and things like that, not necessarily regional. But I think there is much more commonality there, and we should be searching for what holds us together as well as what differentiates us. And I think that's the power of human rights. That's also what development seeks to achieve. Of course, the informal justice discussion will go on. You will see our reports outside. I think there are a few hard copies, but certainly online. And we look forward to hearing from you, because the idea is to collect all these views, create a community of practice, and also see what kind of learning would help practitioners, between academics, practitioners, governments. The state plays a very important role. The state can actually determine the debate very often. The state, and how one supports the state to be able to determine the debate rightly. So thank you very much, everyone. And this is a conversation. This is not the end of it. And we look forward to staying in touch with all of you. And please do go to our website and look at our report and engage with us.
Thank you very much, Irene.